Institute web conference series. At this time, all participants are in a listen-only mode. Should anyone require technical assistance during today's conference, please press star then 0 on your touch-tone telephone. As a reminder, today's conference call is being recorded. I'd now like to turn the conference over to your host, Ms. Jennifer Bartz. Please go ahead.
Hi, I'd like to welcome everyone to our 5th session of our 2012 National Directors Institute Web Conference Series. We are in our 11th annual NDI season, a program which started back in 2002. As with our NDI programs in years past, we're looking forward to sharing the insights and experiences on corporate governance issues that we think matter most to you. The goals and objectives of our NDI program have always been to provide practical insights and useful takeaways to directors, executives, and boardroom advisors. Materials for our previous NDI webinars and other sessions, including PowerPoint presentations and audio recordings, are available on our dedicated NDI website, which is foley.com/NDI. Information regarding future NDI webinar sessions will also be found on our NDI website. We held our in-person 2011 NDI in Chicago on November 17th. Please go to our NDI website to find many valuable program materials from that all-day program. Our next invitation-only in-person NDI will be held Wednesday, November 14th, 2012, again in Chicago, so be on the lookout for more information. I'd like to take the opportunity to thank all of our NDI co-sponsors, many of whom have been supportive to NDI for years, and some who are new to our program this year. Aon Corporation, B.F. King Company, Eversheds, FTI Consulting, and KPMG, as well as our in-kind sponsors, Boardroom Bound, Inforum Board Access, and NASDAQ OMX. Today, our program is entitled The Board's Interest in Protecting Corporate Privacy. And now I'd like to turn the microphone over to Peter McLaughlin, our Foley and Lardner partner, who will begin the program and go over a few housekeeping items. Peter?
Thank you very much, Jennifer. So we're on slide 2 now, and in addition to myself, we have the benefit of 2 experts in the area of international privacy, security, U.S. issues, and the risk issues that are associated with a lot of these complex laws. And Mr. Kenneth P. Mortensen is Vice President, Assistant General Counsel, and Chief Privacy Officer of CVS Caremark, a fairly substantial Fortune 20 company in the healthcare space. And so Ken has a great deal of experience in the areas of international privacy, U.S. privacy issues, and especially how to manage those risks, how to establish where the risks are, and how to allocate resources and make decisions appropriately. And so between Paula, Ken, and myself, we hope to share some of these experiences and provide some guidance to you. On the housekeeping side, the slide indicates a toll-free number for technology assistance and audio assistance. More importantly, you should see up at the top of your screen a Q&A tab if you wish to submit a question. And in terms of printing a copy of the presentation, instructions are below. We are in the process of applying for CLE credit, and in particular, if you are requiring CLE credit for New York, I will do my best to remind you of a specific secret code that I'm supposed to read at the 45 to 50-minute mark to make sure that you are paying attention. So today's topic, pardon me, today's topic is how to manage personal information and sensitive corporate information when the issues involved are going to be rising to the level of senior management officers and directives. So obviously we're going to start off with a brief overview of how and why privacy and information security have become board-level concerns. We will then turn it over to Mr. Mortensen, who will discuss some of the U.S. issues. And I'd also highlight, as I'm sure Ken will, that even though CVS Caremark is a very large U.S. company, these issues apply to companies of all sizes. Paula will then discuss the international issues because, again, companies of all sizes have employees and customers and information all around the world. And then finally, we'll close it out with some guidance on how to actually manage the risk and also try to obtain a competitive advantage in terms of managing your information. And we'll try to save some time for Q&A as we go through. So on the first topic, one of our sponsors, FTI, coincidentally recently released an annual legal risks on the radar survey. And this is a survey of several thousand public company directors and general counsels. And the most interesting thing is that for the first time, data security was reported as the major concern. So as you see from the slide, 55% of public company general counsels surveyed said data security is their biggest issue. And just about half of public company directors feel the same. And this is a significant increase from prior years. I think part of this is a result of the breach notification laws, which have woken everyone up and generated a series of self-reporting obligations. But also it's important because you see an increasing amount of corporate competition, theft of intellectual property, and so forth. So the risks associated with important confidential corporate information are both internal and external. The Sarbanes-Oxley rules have been around for a little while now, and even though Sarbanes-Oxley has no express obligation to, quote-unquote, secure corporate financial data, it is widely expected that information security is associated with the corporate controls. But then there are also other corporate assets to keep in mind. The U.S. Trade Representative estimates that $250 billion, that's with a B, $250 billion of U.S. company intellectual property is stolen on an annual basis. I would say it's lost or stolen, but if it's lost, the evidence seems to indicate that there's a great deal of competition out there. Whether the IP loss occurs in the context of an employee leaving and taking intellectual property along with them, or a competitor trying to sort of break in. We've also seen examples recently with trade secrets being stolen and taken to competitors, new employers, as well as consumer information. On the external side, on the enforcement side, the federal government and the state attorneys general have been increasingly aggressive in terms of managing and responding to perceived risks to personal information. The U.S. Federal Trade Commission, HHS, and state attorneys general have obtained over $100 million in settlements over the last few years. Now, while each of these individual settlements doesn't come near to that figure, I think the most important thing is to understand the internal costs that are associated with remediating and complying with these issues. So I think in closing out this sort of risk issue overview, one of the interesting quotes from the FTI consulting survey was from president of the corporate board member, Kerstetter, who said that there's a bit of a disconnect between, on the one hand, individuals' confidence of their firm's quote-unquote preparedness, but the lack of written plans. So while a great number of company general counsels and directors are expressing concern for privacy and data security, they also have a relatively high level of confidence about their own company's preparedness. But when asked to actually demonstrate that, it looks as though there are relatively few formal written plans to support how a company would manage that risk. And at the same time, over in Paula's neck of the woods, the European Commission is anticipating developing a new law specific to cybersecurity, which would basically involve a series of requirements for U.S. businesses or U.S. businesses operating in Europe to report when systems have been disrupted. So with that, I'm going to turn it over to Ken to take control of the slides and walk us through what he sees as some of the major concerns from a U.S. company perspective. Ken?
Thank you, Peter. What I'd like to do today is kind of give a little bit of talk about the environment that we are living in these days, and as counsels to our companies and those dealing with privacy and security issues, what are the sorts of things that we're going to have to deal with on a regular basis, and kind of follow up with a brief discussion on how do we understand our success or our failures, specifically looking at some concepts of how would we do some metrics for that. You know, as you can imagine, here in the U.S., the space that is privacy and security is fairly complex. Most of the time, the concern that you read about in the media and then from the public is focusing on personal information issues. But for companies, this can go much deeper. Personal information exists both in terms of the data that would exist about the customers, clients, consumers related to the business, but also with regard to the personnel, the vendors, the contractors, and the people who are working within the business itself too. In addition, as Peter mentioned, this goes beyond just personal information, but also proprietary information, and the need to ensure that the information for which there is monetary value beyond the personal information, the business plans, the schematics, the drawings, the information that is at the core of how a business does its work, that information needs to also have the same level of protections and safeguards to ensure that that value is not diminished. And this is made even further complex by the way that the laws are done, both domestically here in the United States, but also internationally, in that there is not perfect alignment. Now, not that we would expect that there would be, and we were used to this in other spaces and having to deal with issues in a fragmented sense, but certainly this becomes much more difficult because information does not necessarily follow the same laws as, or excuse me, follow the same lines as the laws do. Which means that it can be somewhat difficult to align the practices and processes within an organization with those laws. And partially that's why I like to think of the privacy and security programs within a company being part of an information governance framework, which we will talk about a little bit later. But in the space that we have to deal with here, the type of information we're dealing with can have these multiple facets. We talk here, we say health, financial, credit card, children online, reputational information, those sorts of things. And we need to be able to understand the specific requirements that would exist, that exist not only within law and regulation, but may also exist within regard to a contractual obligation. A very easy example of this would be the payment card industry, or PCI standards, which are not law with regard to the protections and safeguards that are required with regard to cardholder information, but are done through private contract and the activities of an organization in the sense of being a merchant that is accepting credit cards. There are also obligations that may exist with regard to our vendor relationships, with regard to the relationships we have with clients, and those will all impose upon us different levels of requirements that we will have to address. In addition, beyond all that, when we are talking about personal information and interacting with the public, we also have to be aware of the broad brush that many of the enforcement agencies have with regard to looking at that information and the organization's collection, use, maintenance, and dissemination of that information. And here we mention the unfair or deceptive acts or practices under Section 5 of the FTC Act, which the Federal Trade Commission, as of late, has used very broadly to look into the activities, especially online activities. And just recently, we saw some settlements with some large groups, including Google, Facebook, and some smaller companies that are dealing in this space and their uses and collection of personal information online. But the FTC looks beyond just the online. They still consider it to be pertinent with regard to the traditional types of consumer information, even that which is collected in a bricks and mortar world. And also we've seen the states get into this. We mentioned here the little FTC acts. Most states have some level of consumer protection, whether it sits within the Attorney General's office or sits within another office. An example of that would be in Massachusetts. The law there, there's an office there for consumer rights, and there is now in effect a law that requires certain protections for personal information of any form, which looks both at electronic and at hard copy information that is collected, used, maintained, or disseminated about Massachusetts residents. And what's interesting about that particular statement is the fact that that applies not only to companies within Massachusetts, but also companies outside of Massachusetts that may have information on a Massachusetts resident. So there is a, if you will, an extra jurisdictional effect with some of these laws as well. And Paula will talk a little bit in terms of international law, but there's the same effect if you think about it in terms of the long arm of the law reaching out from other jurisdictions beyond the United States with regard to personal information, especially as it affects citizens of other countries. But the big area here with regard to personal information on the state level really is, as we mentioned here, the breach rules. And this is, as Peter was mentioning a little bit earlier, the one place where having a written plan and a course of action that can be followed and be consistent is extremely important. And this is the sort of question that is regularly asked at the board level, because the boards want to know what is management doing to mitigate the risk that exists should an event occur that would be a privacy incident. And the reality is, in this day and age, it's not if you have an event, but rather when you have an event. And I know that that's a bit of a cliched way of saying it, but it is the reality. With the complexity of information and the systems that exist today, it is impossible for you to have a system that will provide 100% security. In fact, I would say to you, if you ever have a consultant that comes into your room and sits down in front of you and says that I can guarantee you 100% security and ensure the privacy of all your information, you should immediately kick them out and ask them never to return, because they're lying to you. The reality is that the world that we live in has the ability to provide complexities, to changes, and to make it very difficult to understand where all your information is. I would say that actually electronic information is much easier to deal with than paper information. But I've been asking for the last 35 years, when I was first told that we were going to be moving to a paperless office, when is that going to happen? In fact, my personal belief is that the computer has generated more paper than would have existed without it. But in that case, it means that I also have to deal with something that is very hard to manage in a centralized way. Paper exists all throughout the organization, has its own way of moving through that organization, and people handle it very differently because it's handled on an individual level, as opposed to the data which may be stored on my laptop, which is in an environment which is encrypted and then managed centrally from a user support desk. So breach rules are very important in terms of having the right process behind them in order to be able to understand what do we do. In addition, this is an area of great complexity and one that many companies, including my own, spend a lot of time, effort, and resource to staying up to date on, because these things change. And as we say in the slide here, states, some cities, insurance regulators, certainly these exist with regard to certain data spaces, such as with protected health information, which would be covered under HIPAA, which would be the Health Insurance Portability and Accountability Act that has the provisions for the Privacy and Security Rule, and the Data Breach Rule, which went into effect in 2010. These particular processes have their own differences within the laws and regulations, but it's important that you have a consistent, singular process to be able to move throughout that, and as Peter mentioned, to have consistency in response so that the risks are well understood to the organization as well as the response. What does this mean in terms of the organization? What does it cost us? Well, as I said, because it's a very complex environment in which information exists, it is very expensive to have controls that are going to be segmented. That is, to have the ability to deal with the different types of information and information flows and to put in place the controls that will mitigate the risk in a similar way. This is not a simple process, and it's not a process by which it always works from a top-down or a middle-out approach. Sometimes a bottom-up and a outward-in approach will also be effective. This is certainly one way where you can say that there are many ways to skin this cat, and you need to look at this in different approaches. I would say that within my experience, having worked for organizations that have multiple different types of operations, whether those are businesses or in the case of some of my previous experience working in federal agencies, each agency, each business, each component, each division has its own way and operation of doing things, and you need to make sure that the controls that you put in place are appropriate for those businesses. The more that you can integrate those controls and how things are done, the more effective those controls will be. And then, as I said earlier, there's no doubt that you will have incidents that will occur. And what you need to be able to do is the traditional prevention, response, review, and cycle through a risk management process to be able to understand what is going on. One thing that is true, the quicker you can get more information, the better you are in the long run. That seems like a pretty straightforward and simple thing, and something that you would believe that would not need to be said. But certainly it's something that most organizations have yet to really put in place the plan for. And this is something that the boards are going to be looking at and saying, how do we know what it is that we know? How do we understand what it is that we need to understand? And part of this is going to be able to have the processes we talked about in terms of doing a response to an incident, but in addition, it also has to deal with what are you going to do with the information you have, and should you have that information, and why do you have that information, so that if you do have it, there's a business purpose for it, and that business purpose and the reasons for it outweigh the risks associated with it. And then, as I said, you also need to be able to do preventive activities, defending against various actors. We mentioned hackers, we mentioned competitors, those are certainly big things. Employees, though. One of my colleagues here made a joke when I first joined with the company that said our employees represent how many thousands of ways each day to screw up. And it's certainly true that whether it is an innocent mistake or it is a purposeful theft, the insider threat still remains the biggest threat to any organization, whether it is a school, an agency, or a private business. Insiders remain the threat both in terms of outside actors, but also inside desires. And by that I mean, somebody who is leaving a job, perhaps deciding that they're going to go work for a competitor, or wants to take information that they feel that will have the ability to have that information available, yet that information has great value to the organization. Therefore, to have it gone is a problem. Now, I mentioned very quickly, and I'm not going to take very long, but I wanted to throw this in front of folks and think about how do you deal with understanding your success or failure, or another way to look at this instead of saying success and failure, but is to really examine the maturity of your program. And so I put up here some discussions of looking at some metrics for reporting. For smaller organizations, it may be a little bit simpler in some ways, but any organization will have multiple business lines, different types of operations, and you need to consider how are you going to look at this. Are you going to look at it from a completely enterprise standpoint, or are you going to look at it from, if you will, a business line standpoint? Both have their advantages and disadvantages. And if you notice from the chart that I have up on the screen right now, there's kind of a very consistent, you understand what one advantage is, but then there's the disadvantage that goes with that. So for enterprise, you ensure uniformity. Great. But the con is, well, no one size fits all, as I talked about a little bit earlier. Create some consistency, but then there's non-consistent issues across the businesses. So you can see that there's some, issues there that you need to look at. From a business line standpoint, tailored reporting is one big thing, and I know that that's something in my experience has been very important because it helps the business people feel like that they have that connection to what the metric is. But then by doing tailored reporting, it's difficult to compare how are you doing as between different businesses if you don't have the enterprise. So really the best approach is what I call a hybrid approach. And that way you have certain metrics which may be reported on an enterprise level and bring everything together and consolidate, and then other metrics which are done on a business line level that allow you to be able to provide the depth of knowledge within that particular business and also fit with what that business is in order to be able to make it successful. And then that raises the question of what sort of reporting. Now, here, I'm really kind of thinking in general, but given the talk today of what sort of information would the board want, well, what sort of reporting would you do to the board? And I think there's a couple of questions that you have to ask. First question is size. Size of what? Well, first figure out what it is, but size of what is the data set, how many users, how many employees, how many people are, if there's an incident, how many people are affected, or if we have a database, how many people are in that database, how big is the business itself in terms of a dollar amount. That will kind of be a factor we need to take into consideration of how we would be reporting it. What is the regulatory environment in which this exists? Why do we need to do reporting, or why do we need to look at certain aspects of data? Is it HIPAA? Is it FCRA? Is it GLIB? All of these different rules that we would look at. Is it a state law issue? Is it an international issue? Understand the regulatory right. And also, do you understand the complexities of that environment? Because in some areas it may be HIPAA, but also on a state level it may be personal information. Availability. One of the most difficult things is how do you measure this, and where do you kind of, if you will, put the sensor into the organization to be able to pull out the information necessary to be able to do these measurements. And then from that, how can you do that? Another thing I would say here, especially since there's a good chance a number of attorneys on, you have to consider privilege. When we're talking about availability, that's the same thing. Is it available to whom? Inside, outside, and how you're going to make it available. And then if you're sharing stuff with the board, what level of privilege, what level of publicity is necessary to make sure that it is available there. Cost. Reporting is not free. Many times that is a mistake that organizations will make in feeling that this data already exists, therefore we should just be able to pull it together. But the reality is, in order to do this right, in order to have an effective reporting system and to be able to have metrics that are going to collect data that is efficient in the sense of turning information into knowledge and understanding what the maturity of your program is, there's going to be a cost associated with it. And again, the cost is going to depend upon the complexity of the metrics and also the complexity of the business. And then risk, in terms of reporting. I know that I have spoken to a number of folks that have said, well, I really would rather not know. Well, is that a good position to take? Putting your head in the sand is probably not the best way to think about it. And also, going back to the privilege issue, just because there's a fear of litigation should not be driving a desire to not do a collection and a reporting of the metrics. In this day and age, there is an expectation, especially amongst the enforcement agencies, that organizations are collecting the right metrics to understand how the organization is doing and understand where it is going. And this is actually an excellent segue into the next part of the discussion with Paula, where many of the international organizations are also looking at this sort of area for enforcement, and does the organization really understand the risks? So I turn it over to Paula now, who can talk about the international risks associated with this.
Thank you, Ken. I think one of the important things to note in terms of the international risk is just how broadly this risk falls. You might have realized that there are privacy laws within Europe, but actually there are some 80-plus countries and counting in which privacy laws have been implemented in some way, shape, or form. This includes not just the old economy, but also the newer economies as well. The BRICS countries pretty much have privacy laws. Certainly Brazil has some basic ones. Russia definitely has some, and indeed in some respects, as it's consent-based, it's to a degree stricter than European. India even has implemented some rules there which are more protective in terms of particular categories of data, and that certainly had some impact in relation to how outsourcing deals are done there. So the point is to realize that actually with most of the major trading countries that you might be considering, there will probably be some form of privacy law there, if not now, then coming soon. Singapore and Malaysia, we expect later this year, for example. If you're bearing that in mind, it's also worth thinking about the enforcement mechanisms as well. I think you can largely say within Europe one of the reasons that there perhaps might be some level of indifference in some quarters is what was initially seen as a lack of enforcement activity. And indeed, ironically, to some degree, the sort of enforcement activity we've seen in the US and the high levels of fines that have been made by the FTC in particular has raised the profile of data privacy over in Europe and indeed in other parts of the world, perhaps more so, dare I say, than some of the activity locally from regulators. But that is changing. Certainly, regulators have been pushing to acquire new powers, and in terms of levels of fines, we're looking at the moment at something like 600,000 euros as the sort of level of fines that might be levied there. But what's also interesting is actually that most of the agencies are actively recruiting, they're seeking more funding, and where they are recruiting into their enforcement sections. The perhaps most well-known one being Spain, where actually their enforcement activity and their ability to levy fines actually funds the activities of that particular agency. What's also been interesting over the past year or so is an increasing collective thought process and activity amongst regulators, and there's most definitely a domino effect happening where one or two of the more aggressive regulators, or shall I say more active regulators, have taken a stance against Google or others who've been unfortunate enough to come within their scrutiny. And whereas that initially, Google being a point in hand, there was some initial concerns raised in Canada, then that then had a domino effect in other parts of Europe, even though initially some of those European regulators had said they were quite happy with the activity being undertaken. Now, some of this I raise really because increasingly businesses are operating at an international level. Either they will be looking to physically expand our presence into EMEA in some way or South America, or they will be trading there. Either way, the rules in relation to privacy are beginning to encroach, and it becomes a risk issue that needs to be identified and suitable controls put in place for. So, for example, where might you see this appearing? Well, trading terms increasingly cover privacy rules, particularly if you're dealing with government. They'll be quite tight, but even within the private sector, you will now typically see some rules being included within contracting terms. Some of this is driven by strict regulatory requirements that might specify if a service provider is being appointed to process information, that written contracts put in place with certain minimum language in there around controls on use of personal information and security. But we're also seeing the level of that language and its scope of coverage expanding now as experience increases to cover things such as security breach reporting, auditing rights, and actually going further to specify specific security requirements that have to be adopted by either party in relation to handling of personal information. Alongside that, you may say, well, why care? Alongside that are going uncapped indemnity requests, audit rights to assess cost impacts on changes being swept along into overall change requests or change processes, which could ultimately hit the bottom line if indeed a breach arises. So you could end up in a situation where you have not only statutory liability, but then also potentially liability with your customers or indeed possibly vendors in relation to a breach that has arisen. Where we have seen breaches arise, actually that's been one of the more worrying factors for clients operating, particularly over in Europe. They've been very often less concerned about the regulatory impact, but more concerned about the real-world commercial impact, such as the loss of customer contracts that can arise. And it's certainly true to say that we have seen this. A number of the large-scale breaches that have occurred in Europe have occurred where it's actually been the result of activity of a service provider, and they have then seen very rapidly not only their contracts cancelled by the relevant customer. Unfortunately for them, those are the most reported cases actually have involved government departments in this sort of scenario, and that's really had a very damaging effect on segments of their business. The other element that's worth bearing in mind is that the rules around security expectations are toughening up. It's getting more prescriptive. We started out, I think, with some very generic language about taking appropriate steps to protect the information. But as new rules have been implemented across the world, they've tended to focus very much on data security and become increasingly prescriptive. I'll come on to the situation within Europe generally at the moment, but for some examples, in Germany, for example, you've got where you have to appoint a data protection officer if you have more than 10 people employed. They have to actually specify and have in place specific organizational controls, physical access controls, logical access controls, data access controls, data transfer controls, data entry controls. The list goes on. It's incredibly prescriptive. In Italy, it even goes to the level of requiring details in relation to encryption levels to be applied. In Israel, it's a similar issue in terms of having to appoint data security officers if you have more than 5 databases, for example, and again having to set out specific logs and reporting requirements internally to address data security. So it's quite a detailed level not only of organizational control and therefore administration involved, but also technical controls and potential spend in relation to compliance. As Ken alluded to, one of the focuses very much has been around international breach reporting from a risk perspective here and now. Ironically, perhaps the regimes in Europe are not quite as forthright in relation to security breach reporting requirements at this point in time. It tends to be very much driven by that, either the type of information concerned, so whether it perhaps it involves health data or potentially financial data, or indeed the specific sector that you're involved with. And that's the case, for example, in Japan. So it's very much driven in a very patchy way in relation to any particular security breach where it involves data concerning individuals from multiple jurisdictions. Then one of the more difficult challenges at times can be working out which territory indeed has jurisdiction, which regulator you should be reporting to, or indeed, given the domino effect, considering the communication strategy with multiple regulators. It's also fair to say that press interest in relation to data security breach is very, very high. It's now regularly seized upon as an opportunity to focus on high street brands or other well-known brands. And there's been some very recent examples where you can actually see the direct impact on sales and share price as a result. So the reputation damage, above and beyond any fines that might be imposed, is considerable in this scenario. I said up to date the rules in Europe have been less restrictive, but that is set to change. As Peter mentioned, there's some changes coming through within Europe. They may take 3 or 4 probably years to actually be come into force, but the drafts which are circulating at the moment contemplate that there will be mandatory security breach reporting for all data security breaches at the moment. It's incredibly broadly drafted. And as I say, 24 hours of becoming aware reporting is supposed to occur. There are some caveats around that, for example, if the data were encrypted, but at the moment it's incredibly tight and very sweeping in its scope. Now, the reality of it is those specific requirements, I think, are likely to change, and I'm sure there will be an awful lot of lobbying to encourage at least at the minimum some sort of materiality threshold, and it will indeed be interesting to see if lessons are indeed learned from the experience within the US. But it's what does seem very much certain is that mandatory breach reporting is coming to Europe sometime soon. Oops. So alongside other changes that might be incurred or have to be addressed in the regulation is really the whole scope of administration. With the draft regulation at the moment, it is very much a radical change. It will become a much more prescriptive, administratively burdensome legislative burden. Some might say it is already, but to give you some idea of why there's suddenly comes something which becomes high up the board's risk register, the proposed level of fines for a start-off demand that sort of attention. For the more serious fines, and I use the word seriously in a somewhat generic term, as I'll explain in a moment, we're looking at 2% of the company's global turnover. Some quick maths means that could run into billions for certain companies. Fines of up to 0.5% and indeed 1% of global turnover for what are frankly administrative failures. So, for example, if you don't put in place a procedure to deal with individuals exercising their right to access information that you hold about them, that, as it's currently drafted, makes you liable for a fine of up to 0.5% of the company's global turnover. If you then fail, having put that procedure in place, to respond within the designated timescale of 30 days, then you could face a fine of 0.1%. Similarly, if you don't put in place agreements with other controllers, so other parties with whom you jointly share controller information, then you could face a fine of 0.1% as well. So it's a highly prescriptive regime as it stands at the moment, with some eye-watering penalties for non-compliance. The other big shift, which as yet hasn't received much attention is the potential for class action, as they have inserted in there a right for individuals, for organisations to bring actions on behalf of third parties. Now, at the moment within Europe, we haven't really seen much in the way of class action activity, but that certainly seems set to change that, unfortunately. Why care about legislation which I've mentioned might take 3 or 4 years to actually come into force? At the moment, we're looking at the potential for the regulation to be agreed probably next year, and that may be a little bit optimistic, and then there'll be a 2-year grace period, it seems, before it's actually implemented, because there'll be a significant amount of things to be dealt with during that time. But why care now? Well, there are certain things where actually it makes sense to start thinking about this here and now, because they will have, there are issues that you may be contemplating, deals you may be doing now, which you'll feel the impact of when this comes through. So, for example, I've mentioned there'll be a big increase in records and audits and policies, training requirements, a lot of specific requirements to keep logs, to carry out audits, to keep records, to create a vast array of policies and conduct training regularly. All of that is internal or potentially external cost to put all of that in place. You're also required to appoint a data protection officer who, incidentally, will have protected employment rights, so you can't easily fire them if you don't like what they say. If you have more than 250 employees, although you are allowed to if you have multiple employees within, multiple companies within Europe, you can appoint a single DPO to deal with that. It's a lot of budgeting costs potentially that will need to be built in, and over the course of the next 2 to 3 years, you might well be looking at budgets now which this will hit. And as always with these things, very often some of the more difficult challenges can be identified, whose budget this will sit within, and who will take responsibility for managing that. The cost impacts at the moment are still being calculated. I think people are really just trying to now get to grips with the level of detail within the legislation. Certainly the UK government and indeed other governments in Europe are strongly challenging the somewhat optimistic figures for the cost of impact which have been put forward by the Commission when they proposed this legislation. There is certainly likely to be a significant impact in terms of not just headcount, but also organisational change and indeed the cost of technical procurements, new IT systems, or changes to existing systems in order to comply. In that regard, it's worth noting that one of the requirements here is that there is privacy by design. That's a concept you might be familiar with, certainly spearheaded by the Canadian privacy regulator, but seen now over here as something which is good practice. Going forward, that will become something which is required by regulation, and also, interestingly, privacy by default, so making sure that systems are set up by default so as to protect information correctly. What's not at all clear is how all of this will impact existing systems, so legacy systems. Again, this could all point to additional IT costs. And then finally, just to say, from a consent perspective, from a business development perspective, it is certainly going to get harder to obtain consents to market. At the moment, there's no real differentiation between whether that's in a B2B environment or a B2C environment. It's heading towards explicit consent being required rather than implied consents. And as most marketing folk will tell you, that causes them great concern because of the potential loss loss in numbers anyway of people that they can lawfully contact or communicate with marketing messages. So all of this points towards increased cost, increased burden, which would ultimately be affecting budgets and resourcing internally. So it's something to be, which organisations should be looking at really now. So that leads me on really to go on to information governance, and I think Ken was going to come back here to pick up some of these points.
Thank you.
Actually, Ken, if I can just interrupt for an administrative matter. So two things. One, just for a time check, we're about 10 minutes out. So, Mr. Mortensen, as we go through the next slides, if you could be pithy and concise as well as informative, your usual self. But more importantly, for those of you on the phone who are seeking New York CLE credit, you need to email to Ms. Jennifer Bartz, whose email is jbartz@foley.com, the following 5-digit code, QB6AI. Again, this code is needed only for those requesting CLE in New York. One more time, those seeking New York CLE credits are required to email the following 5-digit code to Jennifer at jbartz@foley.com, and the code is QB6AI. And I will turn it back to Ken. Thank you.
Thank you, Peter. And I shall be very pithy, because I think this is really wrapping this all together. Paula and I have discussed in some great detail the risks that exist there, but really the question here at the end is the one we have on the screen. How will a plaintiff's attorney, a judge, a jury, a regulator, an enforcer, if you will, how will the consumer scrutinize, analyze, an organization's privacy security posture in light of applicable legal requirements? And I mentioned to you the way I like to look at it is in the concept of information governance, and really because that's what we need. Information is no longer a byproduct. If you think of what the word information means, the word information means the ability to use data to communicate knowledge. And therefore, information is not the byproduct, but is the product. And it is the fuel of the engines of any organization. And an organization can only be able to bring value if it has a way to be able to use it. And I like the last line of this Lardner quote is to enable an organization to achieve its goals. So that truly what we're talking about is an information governance approach. That is looking at how does information drive value within an organization in a manner that optimizes risk such that you can facilitate decision making, will address the issues and the concerns that we have discussed on this program. And really, I think that's the key thing. And what are the common components that you would find? And much of this we've already discussed. Risk assessment and mitigation, the processes that are in place. A security organization, I would also say a privacy organization, or I have here at CVS Cameron, I've put together an information governance organization that has those two components within them. Policy and procedures, I think, are an obvious aspect of that. Having stuff in writing, stuff that can be referred to, something that has commonality is important. Awareness and training, can't stress this enough. Paula talked about this as being a requirement. They talked about how this will be judged. Certainly in every single conversation I've had with any enforcement agency, one of the first things they will always ask is, well, what does your training program have? What are you doing for awareness? Testing. If you don't know what the problem is, you better find out what the problem is, and the only way to do that is to test it or to audit it and look at that. Access controls, I would even go further, say not just access controls, but also just any kind of control over the information. Access controls are one type, but you want to make sure, I like to steal from HIPAA, you want to have administrative, physical, and technical controls. That is, have all the means and methods to be able to understand how are you going to provide for the safeguarding of that information. Life cycle. The other important thing is to understand that information does have a life cycle. If we were not on a webinar, I would ask for a raise of hands of how many people know that they have colleagues or themselves that have emails dating back to 1992. Right. Well, perhaps maybe not that far back. But certainly we know we have colleagues that have emails that go back substantially. How many of the files have we kept forever, being attorneys? Those are the sorts of things you need to consider, which is that creating a risk for an organization? Do we understand when the organization needs the information, when is it used, when does it have to be obtained, and when does it have to be destroyed? And then kind of the last part here is the monitoring, the audit, the review. In any good process that you have, if you have management, which is required within governance, management will have to plan, to organize, to direct, and the last thing is to monitor. That's the cycling back to make sure that you have full and complete understanding of what has occurred in it, and you can grow based upon the lessons learned. So being able to do that is critically important in the scale of things. So what are the benefits that you get out of this? Well, you now understand what your assets are. You know how to protect those assets. You can leverage, and we say monetize, again, bring value to it. You can have protections surrounding that protect not only the value, but by protecting the value, you also protect the organization. You protect perhaps also the people that relate to that information. Have the ability to understand how to respond when an event occurs. Here we're talking about breach events, basically, but also by having governance of your information, any event, economic crisis, an operational problem, you now have the ready information there available to make the right decisions. And by having an information governance program, and you can demonstrate the processes that go along with governance, you can plate down and beat down anyone that comes in and attacks you. And that has actually been, in my experience, very, very effective. Going into the agencies and being able to say, we have this process in place. Yes, there was a failure, but it was a single failure, or it was a limited failure. That is crucial. Last thing to mention is you can't forget internal resources. Make sure you have the right people in place. In this day and age, obviously, the right technology in place. And then lastly, what are the external resources that you need to bring to bear? I think that's important to be able to understand. Do I need outside counsel? Do I need internal? Do I need consultants to come internally? What are the resources to bring those together? And then obviously there's the cost associated with it, because nothing is free. So hopefully that has given you an idea of what you can do from a governance standpoint. I will turn it back over to Peter to see if there are any questions that we might be answering.
Thank you very much. So at the moment, that brings us just about up to the hour. If you do have any questions for the for the panel, please do type them in up on the top. In the meantime, we do have a couple administrative things. Here is our contact information for each of us in the event that you want to follow up with with a separate question. And then in terms of upcoming sessions, the final session of the NDI Checkpoints is December 5th, and further information on those will be announced shortly. And there will be an NDI executive exchange in mid-November. So as final note, a copy of the PowerPoint will be available on the Foley website over the next couple of days, and it will include a recording of this. And please do take the time, just a couple of minutes, to go through the survey, because it helps us to make sure that that we're providing content in a way that is relevant and helpful for you. So at this point, I will turn it back to Jennifer.
Hi, Peter. It looks like we have one question in the queue.
Jennifer, I think I can answer. The question is, if an IT department reports to the CFO, how does the legal department normally get involved, and what responsibility to bear? And I think you have to, kind of just consider it's like any other issue. It is a partnership within the organization. As a member of the legal department here at CDS Caremark, as well as being the Chief Privacy Officer, I have a very close relationship to our CFO and our CIO, who reports to the CFO. And to that extent, the security organization that sits within the IT organization actually has I like to call a dashed line reporting to me. It's stronger than a dotted line, but there is certainly organizational coordination to accomplish the goals that are there.
Thanks, Ken. It looks like that was the one and only question in our queue at this time. So we want to thank all of our panelists today for their excellent insights regarding the board's interest in protecting corporate privacy. And thank you again for attending. That concludes our program.
Ladies and gentlemen, this does conclude today's conference. You may all disconnect and have a wonderful day.